and good morning. It is so wonderful to be here today for our bi-weekly coffee chat. My name is Mary Ellen Wilson. We do have lots of new folks that are registered for today's coffee chat. So let me just introduce myself, Visiting Angels, and then we're going to jump right into it. So as I said, my name is Mary Ellen Wilson. I am the Business Development Manager here at Visiting Angels. And at Visiting Angels, we help older adults age safely and gracefully in place, in their home or in their community. We have 4 offices. We have an office in Gaithersburg, which is where I am today. We have an office in Silver Spring, Washington, D.C., and Edgewater, Maryland. So we can really serve a huge area in the whole D.C., Maryland area. We have been doing these coffee chats for a year now. My last guest suggested that we have a anniversary coffee chat party, which I thought was a really great idea. And maybe instead of coffee, we should have like champagne or something. But whatever you have in your cup, that's your business. Good for you. I have coffee today. We started doing these when the pandemic hit because we were used to getting out into the community and doing community events like this. Just like everyone else, we were shut down, and I can't stand being in an office without seeing and speaking with our community and some of our wonderful industry partners. Thus, the coffee chat was born. So today's coffee chat is really, really exciting. I have invited Andrea Baddour of Baddour Law Firm, and she is an elder law attorney, and she is going to tell us everything that we need to know about estate planning. And what I think is so important that everyone realizes, it doesn't matter what size estate. You really need to plan, or the state, as in state of Maryland, will do the planning for you. And that's never a good thing. So Andrea, like I said, she owns the Baddour Law Firm. She is a graduate from the University of Maryland's Francis King Carey School of Law and has been practicing law since 2002. She has argued several cases before the Court of Special Appeals of Maryland, and she served as the Calvert County Board of Elections attorney since 2005. Among Mrs. Baddour's accomplishments as a trial attorney are 2 published opinions before the Court of Special Appeals. And she has also regularly been invited to speak throughout the Tri-County area on issues of estate planning and estate administration. Before I welcome you, Andrea, I always forget the housekeeping. My apologies. Should you have questions during this coffee chat, we love questions, and we're going to leave a lot of time at the end to answer them. So you can put them in the chat room, or you can, of course, put it in the Q&A box, whichever is easier for you, but we will save you time. And Facebook friends, hello, we are now live streaming on Facebook. Should you have any questions, my lovely Facebook friends, you can just put your question in the comments and we will get to you as well. Andrea, hello, welcome. How are you today?
Thank you. Thank you for having me. I'm doing great. I get to talk about my favorite topic, which is estate planning. So hopefully you'll find it as exciting as I do.
Well, I know we're going to. So, Andrea, I'm just going to ask you to get as close to your microphone as possible and make sure it's up to its fullest volume. All right? And then as soon as you are situated, we are ready for you.
Okay. All right. Is that better?
It is.
Can you?
Yeah.
Okay. Good. All right. Well, thank you again. And I hope that you find this session informative. And again, like Mary Ellen said, any questions you have, we're here to answer. So what I want to briefly discuss is the basics of what you need to know about estate planning. And like Mary Ellen said, everyone has an estate. Even if you think that you don't own a lot, everyone has assets and assets protection that needs to be followed. So Our first screen is the big question that a lot of people ask me, and that is, do you need a last will and testament or revocable living trust? We hear a lot in social media and through the public about these revocable living trusts. And in Maryland, they're becoming more and more popular. Um, One reason is because the legislature is giving us more and more power to create living trusts and what we can do within the trust every year. And secondly, it's a great vehicle to accomplish goals that we can't accomplish necessarily with a last will and testament. A last will and testament, of course, we're bound by the statute of Maryland, and it goes to the orphans court and the register of wills in the county in which you reside. Although I say that every register of wills in this state, I've had a wonderful experience with each county, but it is a court process. And as such, when you're making your first determination of whether to have a will or living trust, here are some components that you might want to consider. Um, a will, of course, like we said, is subject to estate probate proceedings. It is public. Anybody can go online and see any will that has been opened. I do it daily, and you can even go online yourself and do that. Um, a will is triggered upon your passing, upon a death certificate, and then the assets are transferred upon your passing to your loved ones. A will, in essence, can't provide for any disability that might pertain to one of your beneficiaries. The plus side of having a will is it is less costly up front to do. The other option to having a will is to create a revocable living trust. The benefits of having a living trust is it's not subject to probate. It is more costly, however, to set up because it's more timely to set up. Will is roughly between 4 and 6 pages. Living trust can be anywhere from 20 to 30 pages. So it just costs more time to do it. I always say a family revocable living trust to do it right, including funding, takes about between 18 and 25 hours to complete. So there's just a lot of time for the office to prepare. But a living trust is private. We do not register a living trust with the Register of Wills, and it controls your asset during your lifetime. So because you're changing ownership during your lifetime, you have a lot of control over what happens because you're doing it during your lifetime rather than after passing, well, in the case of a will. A revocable living trust provides for disability, and that is a wonderful vehicle if you would have a special needs beneficiary. We can set it up so that it provides a contingency plan and for something set up for the next generation if you do have a special needs beneficiary. So over time, when you're looking at the two, depending on your asset portfolio, it can be less expensive to do a revocable living trust and therefore save money for your loved ones.
Okay, so I've got to get a few clarifications here.
Yes.
So first off, what are the advantages of avoiding probate?
Good question. Probate is costly in the sense that, yes, you pay the Register of Wills a fee, but most people employ an attorney to help them through the process. I always say that probate's like its own language. And unless you want to speak the language day in and day out, you might want to hire an attorney who speaks the language and can accomplish that task for you, depending on the asset holdings. I've had personal representatives that say it's a full-time job being a personal representative. So you pay an attorney to walk with you and to do all those filings with you so that you don't have to take your time in preparing those documents. And so if you don't go through the probate process with a living trust, then of course now you're saving all those attorney's fees that might accumulate if your loved ones have to go through the probate process.
So as an executor of a will, it's my duty to either get through the probate process myself, which I'm not trained to do, or hire an attorney to help file and get you through the process. Correct?
Absolutely.
And
Absolutely.
you avoid all that with a revocable living trust. Makes perfect sense. All right. What about, can you talk about estimate the average cost of a living trust?
Well, it depends. Living trust is unique too because you can hold that together as a family. So if it's a husband and wife, obviously the cost is greater, but being able to have everything in one pot is really nice. The cost of a living trust varies greatly because it depends on the asset portfolio. Since we're transferring all the assets into the living trust, there's costs with each of those that we incorporate in the cost
Okay,
for a
gotcha.
trust. But again, far less than what it'll be for probate. For example, if you have real property, we're going to draft a deed and record that deed in the name of the trust. Obviously, the more deeds you have, the more expense there is, both on the expense side of the filing and also the drafting of the deeds themselves.
Got it. So it really does, it's determined by the estate itself, is what I'm
Yes.
guessing. And one last question before we go on. With a revocable living trust, are you avoiding estate taxes versus having a will?
No, I wish I could say yes on that question. I
I was
know
hoping you would
it
say
would be
yes.
great. It would be really, really great.
That's
No,
great.
but we can't avoid estate tax. However, I would argue that because we're creating a living trust and doing it during your lifetime, we have planning tools that we can assist and hopefully manage any potential estate taxes in the future better than we can with a will because we're
Got
hit
it.
when the person passes. So in the law, so in the short run, the answer has to be no, because we're not able to avoid in a living trust estate tax. But because we can plan for it, essentially there usually is a savings because
Terrific, Andrea. All right, let's move on. I know people will have more questions towards the end, but I wanted to get those items covered.
okay,
Okay.
please. Okay. So we talked about the big first question is whether you get a last will and testament or a revocable living trust. Whether you choose either vehicle to get your items to your loved ones, you need to have other estate planning documents to go with those. So with either your trust or your will. Number one is your power of attorney. I cannot underestimate the value of a power of attorney, both on the medical side and the financial side. So a power of attorney takes care of you during your lifetime when you cannot make decisions for yourself. Again, either medically, financially, or both. And in the instance of a will, a power of attorney expires upon your passing, and then the last will and testament is the activated document upon your passing. It's very important to understand that your power of attorney expires when you die. So that's why you have to have both a power of attorney and either a last will and testament or a living trust, because your estate plan is not complete without both of these documents. In the case of a power of attorney, your loved ones currently cannot go with you to a hospital. It's very important that they have a power of attorney on file so that the doctors, nurses, and hospital personnel know who to contact for medical decisions and financial care. I think it was like last month, the power of attorney was updated both on the medical and the financial side to include COVID language, permitting power of attorneys to act over this type of forum, a Zoom or some type of telehealth. And on the digital financial side, power of attorneys can now sign e-documents. So very, very, very important to have a power of attorney in place.
And how
And
do we go about, and so that's a matter of signing documents with a lawyer to set that up?
yes, so
Okay.
in Maryland, a power of attorney has to be witnessed and notarized.
Okay.
So it's very important that you have that. It's one of those things that you want to make sure is you have the most updated language. So if you have an older power of attorney, that is a document you might want to have reviewed. It's not that they're invalidated, but we want the newest language so there's no hiccups along the way. And unfortunately, we only find out there's a problem or a hiccup when someone's incapacitated and we can't make decisions, and then we can't at that point update a new power of attorney. So while you're able to have a power of attorney updated, you need to have that reviewed with the newest language. And from any age, you need to have a power of attorney. I mean, unfortunately, with this pandemic, we're seeing younger people go
Yeah.
into a hospital and need your power of attorney. So across the board, please, please, please have a power of attorney. I used to say, we used to get calls from the hospital all the time where, as attorneys, we would go in and draft power of attorneys for individuals that were needed, that were staying at a hospital for various reasons. We can't even do that now. So you have to have your power of attorney before you go into a hospital situation. I get calls for individuals that need power of attorneys before a major surgery, and that's a perfect example. Please make sure that you have your power of attorney done in advance. It's a very easy document to complete. It's not that time consuming, it's not that costly, and it becomes invaluable to your loved ones. Incorporating your power of attorney, you can also provide for guardianship, which is another way of taking care of your loved ones during their lifetime. And again, if you don't have those provisions, it can be very costly and time consuming for your loved ones if they have to go through a court guardianship proceedings. So please, please, please have those in effect. Combined with a power of attorney, it's a separate document, but also either a living will or a Moles form. As an attorney, I only can help someone complete a living will, and that's the end of life decisions. With your doctor, however, they can help you complete a Moles form, which is medical orders in the state of Maryland that dictate your end of life care. And a Moles form is incredibly it's really neat to review because it goes over all the type of current apparatus, medical apparatus that's available, and how long you would like to be on that apparatus if you're in certain medical conditions or receiving certain medical treatments. So either have a living will or a Moles form to accompany your power of attorney. All right. So I go over the top reasons not to have a will or a trust, really to spark discussion. And it's also a little fun to show that we can have fun in the world of estate planning. The first is I'm never going to die. And we joke about that, but I find that people don't want to do estate planning because they're afraid that they have to talk about death, or that means that they're going to die. But really, having your estate plan in place gives you a peace of mind. And I always tell people, you do your estate planning, put it on the shelf, and then enjoy your life. So please, no matter what your age is, have your estate planning done. If you have small children, provide guardianship provisions for them. And hopefully you don't need it. And if you don't, those provisions will just smooth itself out. Secondly, as we discussed at the beginning, people say, well, I have no estate. Well, everyone has an estate. And if you don't provide for it, like you said on your introduction, we don't want the state to make decisions for you. And they will if you haven't provided for them. And it's really a last gift of love and affection for you to provide for your loved ones and make their path after you pass easier. And I can't tell you how, when beneficiaries say, oh, my parents put this in place, they made this so easy for me, you can see what gift it is to give to your loved ones to have that in place and reduce their workload when they're going through grief and a hard time anyways with your passing. The third is, everyone says, well, I have everything jointly with my spouse or a child. Well, when you're in a spousal relationship, usually when the first spouse passes, probate and estate planning is easier because you do own a lot of things jointly. But you could have a common accident with your spouse. And statistically speaking, a lot of spouses pass within a short period of time from the other. And you have to have that estate planning done. And also, we also find even when one spouse passes, maybe they forgot to add their spouse onto a vehicle or forgot to add their spouse onto a bank account, and then we're probating, those particular assets. So that's not a foolproof plan that you have your spouse on everything. And for children, I see that a lot of times people say, I'll put my children on, that'll be my estate plan. That can be problematic in itself. And of course, we'll have to discuss every individual plan, but you could be adding someone's credit scores to your credit that you may not want, and vice versa. And additionally, you might trip some tax implications that you might not want to do for both yourself and your children. So that's definitely something that we need to talk about, that normally is not the best estate plan. Um, Fortunately, people say, estate planning is expensive. Yes, estate planning is expensive, but it's more expensive not to have estate planning. When you pass, there's going to be expenses either on the probate side or some type of estate tax or inheritance tax. Let's discuss that now in advance and minimize that for your loved ones. And then fifthly, my family will take care of everything. As I previously stated, a estate plan is a last gift of love and affection. Just leaving everything up in the air and saying your family will take care of it can be a burden, and also your family might miss something. And that's a shame if you spent your life saving and preserving, and they don't know that an account is out there to file a beneficiary claim on it or to access the funds that you've been saving. So it's really a shame not to do estate planning and just leave everything to your children. And I can't express the both the fear and the stress that I see on beneficiaries when they come in with the 18-gallon plastic tubs and go, "This is what my family left me," and we're going through receipts and mailings.
Yeah.
It really is sad, and especially during such a difficult time as it is. And I hear a lot of loved ones say, they want to keep that family harmony, and estate planning also is a way to keep that family harmony together,
No kidding.
because they know
Yeah.
exactly what your wishes are.
Right. Awesome. I will say the first reason I'm never going to die, when I was younger, I didn't really think that, but I did think, oh, if we set up our will and the guardians, I'm putting it out in the universe, and
Yes,
then I will die. So, but that is not the case. I'm still here to tell the tale. So, yeah.
yes. And people tell me, I went to sleep thinking, reminding myself I need to do a will or something. And it's I can see the burden on them, but once they have all the documents in place, really you put that aside and you get to enjoy your life. It's not on your to-do list, your daily to-do list, and it's complete. And it's one of those things that you can do and not have to look at. So yes, we might have to have those difficult conversations about planning for your passing, but once you do it, then it's done. And we don't have to revisit it, and you don't have to have it on your mind daily.
You're done, done and done. All right, let's move
Done and
on.
done. There we go. So summary, you need to have either a will or a trust, plus a power of attorney for financial and medical care, and then also a living will or a MOLS form. Language is important. I know that on the internet and so forth, they provide to do online wills, but language is crucial when it comes to estate planning. So you need to go to a specialist for it. My most costly estate litigation was for one line in an online trust someone had ordered, and it was just one line that was messed up, and we had to go full-fledged litigation for it. And every time the person came into my office, they said just one line. And that just reminded me over and over again how important language is. Last will and testament language has been around for hundreds of years. It has to be on point. When these documents are in play, you have someone that's passed. And that means that we have to hire experts and so forth if we do estate litigation. So it's just very important that you seek a professional to do your estate planning documents. You might spend more, but your loved ones will save so much in the future. Learn also as much as you can about the process. I love when clients come in and say, I've been researching revocable living trust and it's, exactly what I think I need, or a last will and testament or so forth. It really is you get to know the lingo. It'll help in your drafting, and also have some fun with it. I know we're talking about end of life decisions, but it's also something that you've been preserving and saving for. And so you're giving a gift.
Yeah.
So it's fun, and it's fun to plan what your loved ones will do with that, and to plan out the gift that you're giving future generations.
Wonderful. All right. Wow. So let me just review, actually ask you to review. So
Yes.
it sounds like we need either a will or a revocable living trust. That's one, plus a power of attorney for medical and a power of attorney for financial. So those are two different documents, correct?
Well, there are two different powers. They can in Maryland be on the same document, which is really helpful. We used to do
Okay.
them completely separate, and then someone would have to run out for a medical emergency and not take the financial, and then find out later at the hospital they also needed the financial. So they are in one document, but they're separate powers, so that you can elect to have two different people serve, one in the capacity of medical, one in the capacity of financial. You can also have two people serve together if that's your family structure and
Okay.
you would prefer that.
All right. And then a living will. And a living will, if you could just define that for us specifically.
Yeah, so a living will has a very small window of applicability. It's for either a terminal condition or a persistent vegetative state, and it's when death is imminent. Now, I'm not, of course, a medical doctor, so I can't define that, and we all have our different interpretation of what eminent is. But just from that language structure, we know it's for a very small period of time, and it provides if you would like to have life-sustaining procedures, or if you want hydration, nutrition through IV. Of course, if you're conscious and able to make these decisions yourself, also the living will not be in effect. So it's a very small window of applicability, but in that time, it really gives your loved ones some guidance and a peace of mind that they're doing exactly what you would want done if that's in that situation, if you could express those wishes to them.
Great. Okay. Let's go to questions. I'm first going to go to the Q&A box.
Okay.
And the first question is, will there be a printout? I won't be able to take notes. We do send out the recorded version. And Andrea, do you have a printout as well that we can send a link?
Yes, I
Okay,
do.
great. Yes. So yes. All right. Next question. My husband and I have no children. Why would we care about probate? Good question.
Well, because you don't have any children does not, one, mean that you, of course, have assets, but two, um, the courts are going to leave it to in line succession for the second spouses, whoever dies second, their bloodline. That might not be necessarily what you want to do. You may want to leave to nieces and nephews. You may want to leave to a friend, or you might want to set up
Charity.
something to leave to a charity,
Yeah.
which is a great vehicle. And, in discussing that with an attorney, there's tax advantages to leaving some of your money during your lifetime to a charitable donation. And then there's, afterwards, when you pass, also some advantages to your estate. But you worked hard for your assets. You should be the person that decides, you and your husband, who gets your assets after you pass. And your assets can be very helpful to loved ones even beyond your children.
Awesome. Okay. Can more than one person be power of attorney or be the power of attorney? Can more than one person? Can you split it up or
Yes,
have two?
absolutely. And I always leave this discretion of the clients, because of course they know their family better than I do and the dynamics. So the number one factor is, how does your family get along? If you feel that they can work together, you can have them serve jointly. Um, But if there's a lot of family turmoil, I don't know if that would be in your best interest. Also, with the power of attorney, proximity plays a role too. Although we can do things now by telehealth, um, for serving as a power of attorney long term, proximity will come into play. And also remember that you can divide those powers. If you want two people to serve, but you feel that somebody's strength is maybe in the medical area, and maybe one of your other children have a strength in the financial world, you could divide those powers and have one person do medical and one person do financial. So they can serve jointly or serve as under different powers.
Okay. What documents need to be registered with county/state court system, and how is it done? And can you also discuss the different types of power of attorneys? I think we
Okay.
just did that part.
Okay,
Yep.
so what needs to be registered? So during your lifetime, you do not have to legally register anything. Upon your passing, your will needs to be registered with your county's register of wills, which is also the orphans court. We do offer, like all attorneys, we can place your will in what's called safekeeping in the county in which you reside. So what that county does is they do not open that will. They do not have the authority to open that will until they receive a death certificate, but they keep it on file so that when they do receive a death certificate, then they can formally register your will. So your will at some point will be registered. The reason they keep it in safekeeping and don't open it is because during your lifetime, you have the right to make whatever changes you would like. So it's not formally set into place and registered until your death. So that is the only document that has to be formally registered. Your power of attorney is your personal document. You can give it to your doctors. You can give it to your hospitals. A lot of people prefer to do that and have it on file, but there's no requirement. It's your personal choice.
Okay. All right. Can you send the slides of it? Yes, we are sending the slides of this presentation. Is it better to leave a brokerage account to one's estate or to specific beneficiaries to avoid probate?
Well, a brokerage account works a little differently than a retirement account. For a retirement account, there's certain rules that go with leaving that asset compared to a brokerage account. And it really depends on the context of the brokerage account. So that has to be something, unfortunately, I'm sorry to circumvent that question, but it needs to be individually answered because it depends on who's holding it, what the appreciation is, and so forth. So there's not really a direct answer to that.
So who would they would talk to the brokerage firm itself?
The brokerage firm or also an attorney, a estate planning attorney.
Who actually is looking at it, right? I got you. Sorry.
Yes, exactly. Because there's different types of accounts when we say
right. Gotcha. Are inheritance taxes unavoidable?
Really good question. And I'm glad you asked this question because Maryland we get a bad rap, but really, okay, so in Maryland, we do have inheritance tax. However, Maryland's inheritance tax is either 0 or 10%. And a lot of people end up paying 0 for the inheritance tax because if you leave it to direct bloodline, your spouse, your children, your stepchildren, grandchildren, step-grandchildren, siblings, there is 0% inheritance tax. So if you leave to any of the direct bloodline, yes, you're avoiding inheritance tax because you're going to be assessed at 0%. If you leave to friends, nieces, nephews, more indirect bloodline, cousins, second cousins, so forth, then there will be a 10% inheritance tax that the Register of Wills will issue a formal bill for. So I always tell people about, of course, the inheritance tax, not to discourage you. You should leave your assets to who you want, but we need to be mindful that that will be something that will come into play, and you can provide for how that tax will be paid within your estate planning documents if that's of concern to the individual that's receiving it. You can have the estate pay for it, for example, instead of the individual. So there's ways to provide for that. So direct bloodline 0, everyone else 10%.
Okay, all right. Can you address how to avoid the all too possible family disagreements after your death. Yes, have it all in writing.
Yes, and plan, plan, plan.
Plan.
Yes.
Mhm.
Again, that's why it's the last gift of love and affection. The more planning you do, at least in my experience, you're going to see less and less disagreement because everything's laid out. And with the living trust, those provisions are already in place. So that's why planning is so important. When you're silent, then that leaves room for disagreement and interpretation. If it's clearly stated, you really can't argue with the written word.
Mhm. Terrific. If I move from Maryland to another state, would I need to redo my revocable living trust or my will?
Uh, Good question. So wills are state specific. That does not mean that it invalidates a will because you move out of state, but it's interpreted under the laws of the new state in which you reside and pass in. So we always say to review and have a will either reviewed or redone if you move out of state. For a revocable living trust, you do not have to redo the funding. You do not have to redo the living trust, which makes it sometimes advantageous for someone that plans on being very mobile during their lifetime. However, you should, especially if there's tax advantages, bring that revocable living trust under the jurisdiction of that state. I do this, I bring revocable living trust into the state of Maryland, and my counterparts in other states bring it into whatever jurisdiction they reside in and work in. But the cool part about a revocable living trust is it's usually only one paragraph that we're amending. So it's very little cost. And again, we're not redoing the funding, we're not redoing your 30 pages, we're only redoing one paragraph that basically says the jurisdiction will now be whatever state it is, and that we have the power under the living trust to do that. So revocable living trusts are able to go from state to state with just one amendment.
Okay. Wow, you sure do know a lot. All right, more. We have tons of more questions. Someone would like more detail on the difference between a living will and a most. She had never heard of a most. And what is most? What is does the acronym actually stand for? In most.
I was thinking about that when I was doing the slide, and I apologize.
Oh,
I
that's
don't.
okay.
I forgot what it stands for, but
I'll
I
Google
always
it.
think of it as medical orders because it starts with MO. A MOLS form is a document you need to complete with your physician. It takes, I hear, about 45 minutes. And the reason you have to do it with your doctors, since it is medical orders, you have to go over all the apparatus. So they will talk about each apparatus that's available, how long you would like to use that, and under what conditions. So it's very exhaustive to have, and it's just a great resource. Like I said, I unfortunately cannot complete that with you because it is medical orders, but speak to your doctor about doing that. And obviously you might have to pay for his time or go through your health insurance to have that covered. But if it's something that you would like to pursue, you can Google just the context of what the MOLS form contains. But again, you cannot fill it out on your own.
And it stands for medical orders for life-sustaining treatment. Medical orders for life-sustaining treatment. So can you do an advance directive in place of a most? And is an advanced medical directive the same thing?
It's not exhaustive like the MOLS form. The
Gotcha.
MOLS form goes over each type, and it changes sometimes. And again, I'm not to speak to the different apparatuses, but it goes over the different medical apparatus that are available and how long you would want it, days and hours, and under what conditions. So an advanced directive doesn't include all that specificity.
Gotcha. All right. Here's an easy question. How is easy? That's what I can say. How is fine art handled in estate planning?
Fine art. Well, it depends. If you have it already appraised through your insurance, we can use that value when we're either specifically bequesting it in a will or and utilizing that for a trust. But if it hasn't ever been appraised before, it will have to be appraised when you pass. If you utilize a last will and testament, you will have to, your personal representative, whoever that will hire an appraiser and have the fine art appraised before it's distributed to your loved ones.
We have a disabled son who is on Medicaid. Will a third-party trust work for setting aside funds in case he loses his benefit?
This is actually a very involved question regarding the special needs. Yes, estate planning will provide for him, but we need to talk about long-term care solutions. And what I think this question is speaking to is trusts are used as a vehicle to help special needs individuals, because you don't want to give someone who's receiving disability a huge inheritance one year and then nothing the next year, because then their income for the year they receive the inheritance will go up and they could potentially lose their disability status. So a trust can provide in the instance of helping someone purchase things that are not provided for under their Medicaid payments and doesn't also harm their income level. So yes, a trust could be a vehicle for that. There's lots of different types, so individually have to discuss which one is best for your family.
Okay. All right. What is the difference between an executor and a trustee? There is no friend or family member who can do these jobs. What should we do?
Yes. So an executor in Maryland, it's called a personal representative. Those terms are used interchangeably. A personal representative is your individual you appoint under a last will and testament. A trustee is someone that is appointed under your revocable living trust. So a personal representative is with a last will and testament, and a trustee is with a revocable living trust. Essentially, they do the same thing in the sense of carrying forth your directives once you pass. In choosing someone, that's always a difficult question for anyone. A lot of people choose family. Some people purposely don't choose family. There are people both on the financial side, brokers, financial planners, attorneys, bankers that can serve as trustees if you don't have anyone that you would like to personally appoint. Of course, they will be compensated for their services to serve in that capacity.
Okay. All right. Will you advise having a living trust for foreign real property assets?
Foreign real property. Yes, you definitely need to incorporate that in estate planning. It depends on the country where the real property is, and that will create what we can do on our estate planning side. I've had instances where we have real property in different states and we have an attorney, and I mean, not states, pardon me, in different countries, and we have an attorney in that country, and we can sort of bridge our estate planning with ours. So it just depends where the property is being held.
Okay. All right. The question here is, so fine art requires appraisals. What about family heirlooms, example, jewelry? What determines how objects pass to children?
It would, as the last question first, well, how would it be determined? If you just say, like, I want all my jewelry to go to my children, your personal representative will be the individual that's going to divide that evenly. As far as the value for jewelry, there are jewelry appraisers that we use all the time. If there's a lot of jewelry, we can get a lump sum fee for that rather than individual pieces. If you've had it recently appraised for insurance, that's also a great way to save some money from your estate and utilize that.
All right. And then finally, I think finally, okay. How does transfer at death work? I have heard that without it, regarding insurance, brokerage accounts, etc., there can be delays for years. I have also been told that your insurance agent may need a signed agent of record in order to keep the insurance information up to date.
Hmm. I do not know about the last part with the individual life insurances needing someone on
Mhm.
file. In my experience, you have a life insurance policy, you have a beneficiary form on file, and whoever's listed in the beneficiary gets a check upon presentation of a death certificate to the life insurance company. And that's why it's so imperative that you keep your beneficiaries up to date, because they are going to write a check to whoever is listed. So if it's, someone that you do not want listed, you can't change that, after someone's passed. It has to happen during their lifetime. So the way the transfer on death works, though, is you produce a death certificate, and they are correct. It's not immediate. A lot of the financial institutions have their own section that deal with people that are deceased, and you submit it to them, and then they cut the checks accordingly, or they can transfer it in kind as well. So it depends on how you want to receive it. But transfer on death is a great way to get your items to your loved ones.
Okay. How does the legal process work if someone passes away out of the state where he or she lives? So you're on vacation, maybe, and pass away.
Well, in that situation, you still are a resident of the state of Maryland. So your probate action will still be in Maryland. As
Okay.
far as logistics, I've had this happen, and it is a little bit more work on your beneficiaries. Of course, they're receiving a death certificate from another state, so they have to coordinate that. You have to coordinate with a funeral home transportation of the remains and how you would like that facilitated.
Mm.
But the funeral homes are used to seeing this. They have great contacts with other individuals, and they have a group that they're able to coordinate transportation, and they will take that burden from you. Obviously, it comes with a cost, but it is something that can be feasibly done. So please still go on vacation. Don't worry.
Alrighty. So, last question. How do you make sure someone helps your loved one manage finances when they become incompetent? Plan.
That is why the power of attorney is so important. And you have to execute a power of attorney before you become incompetent. Otherwise, you have to go through other vehicles like guardianship. So it's imperative that the loved one has the power of attorney. Once you have a valid power of attorney, and someone is, medical doctor said, one or two medical doctors, depending on what the power of attorney says, cannot make financial decisions, then you're able to act on their behalf and do whatever you need to do. You step in their place. So you can sign as power of attorney their checks, your name, comma, as power of attorney. You can operate in any financial capacity that they can. At least that's what my power of attorney would provide in language, and most power of attorneys provide in language.
Great, terrific. Andrea, where can our viewers find you if they want to reach out and ask more specific questions or start the planning process with you?
Well, thank you. I have this next slide. So this is our, I say estate business planning is all we do. We do free estate planning consults because every estate is so individualized, and we want to create a plan that's for your family. So we do free estate planning consults. We can do it virtually, or we can do it in person. We have 2 office locations, one in Calvert County and one in St. Mary's County. And we also can come to you. So whatever format you would prefer.
Terrific. All right. Any last comments from you, Andrea? This has been so informative. I am impressed by the level of intelligence of our viewers today on this topic.
Yes,
Some
yes,
really good questions.
yes, absolutely,
Yeah,
absolutely.
definitely so. So thank you so much. So I just asked if you have any last comments, and then I'm just going to keep talking. So go ahead,
Oh
Andrea.
no,
Any last
thank you,
comments?
thank you so much for having me. And I agree with your comments. I mean, the questions were excellent. I'm so glad they asked them. A couple of them, I said, "Oh, I feel bad that I didn't include that information in my slides." So thank you so much for the questions. And we're here. We also, in addition to estate planning, we also do the probate administration, which is after someone passes, we can help you through that process. If you are personal representative, carry forth your duties. So that's the two sides of the coin we do, but it's always a better place to be. And if the more planning you have, hopefully that process will go smoothly for your loved ones.
Wonderful. Andrea, don't apologize for anything. I think your presentation was on point. Our viewers have fabulous questions. We will send you a link to the recording so you can listen to the whole thing all over again, but we will also send you the PowerPoint printout, so you will have that as well. Here is Andrea's number. Again, it is the Baddour Law Firm. And of course, in the email that you get as a follow-up, we'll have my contact information as well, should you need to contact Visiting Angels. So I thank you so much once again. Thank you, everyone, for tuning in. And we will see you all back here again in 2 weeks. Thank you. Take care, everyone. Bye.